have two sessions with the legal firms, and the first one will be on offsets, and the second one will be on other legal and taxation issues. And for the session on offsets, may I invite to the dais Ms. Seema Jhingan, partner of Lex Counsel. Ms. Jhingan, please. Also, this session is going to be conducted by my colleague, Atika Wadhwa, who I think some of you dealt with, who also is the lead author of our report on the defense opportunities in India. And just one more note, soup is going to be served inside the hall to where you're sitting at 1:30 or 1:35 or so. We know that we're starting the lunch a bit late, and I think we're just about 5-6 minutes behind schedule now, and I think post-lunch we'll make sure that post-lunch we're back on schedule. Atika.
Thank you, Alok, and good afternoon, everyone. We are ready for the session on update on defense offsets. I'll briefly introduce you. Ms. Seema Jhingan is Senior Partner at Lex Counsel Law Offices. She has over 20 years of experience. She has extensively advised in areas including mergers and acquisitions, defense and aviation, venture capital and private equity, franchising, media and entertainment, software technology, general corporate, and commercial. She has substantial experience in representing legal matters related to defense procurements, bidding process and bid strategy, government contracts, negotiation and collaborative offset alliances and JVs, export control and offset compliances, technology licenses, and so on. Additionally, she's been designated as a leading lawyer in the area of IT and media and telecommunication by Asia Law and Practice. Ms. Jhingan, over to you, please.
Good afternoon, everybody. So we've been having some heavy sessions, very informative too. I'll have a different scheme. I'll have a presentation, and we'll have question answers subsequent to that. Oops. How do we just, okay. Okay, so as we've heard, India is one of the largest importer of defense equipment. And here comes as an offset to that, a trade-off, I would say, an offset policy for augmenting the Indian defense systems, and as an offset for getting the procurement into India. So simply put, an offset is basically a trade-off. It's a situation where the OEM, the supplier from outside of India, agrees to provide certain capabilities or assume certain investments in India against the procurement cost and acquisition outflows that the Indian company and the buyer would be having. So that's the offset, which is a sort of a barter system, as you may put it. India adopted the India offset policy in 2005, excuse me, and it has been revised over the years, and the current offset policy is presently into the DPP, Defense Procurement Policy of 2013. Now, while the rationale for the offset policy is to have localization of production, to have augmentation of the research and development in India, and also to have competitive Indian enterprises, we haven't seen the fruits of the offset. We haven't seen the industry of offset to bear the kind of results that we had expected. And to counter those issues, the government established a committee, the Dharendra Committee, to understand and evaluate what has been lacking, what are the issues that we can promote the Indian industry through the offset mechanism, and also they wanted certain more updation to the DPP 2013. So while the Dharendra Committee has come up with several new suggestions for the offset policy of 2013, there are certain changes that the government has already done in the offset policy, and I'll be focusing more on the policies that has happened in the last 3 years, primarily in the last one in the offset policy, and what are the international best practices that are going to be implemented in the 2016 policy, which has been suggested by the Dharendra Committee. Now, to start very briefly on what exactly is an offset policy and when does it kick in, basically when the estimated cost of procurement by the Indian government is more than 300 crore, the offset policy gets into play, where the foreign OEM has to seek to invest or commit to invest into India. Now, this threshold, interestingly, has been now increased is proposed to be increased, and it's already been passed by the Defense Acquisition committee from 300 crore and 2,000 crores. Now, the rationale behind this updation is that offset doesn't come free. While you will have the long-term benefit to the Indian players to have an offset facility, but the long-term situation is once you have an offset play into the acquisition process, at the end of the day, the Indian government ends up paying the offset cost because the OEMs are building up the cost of the offset into the acquisition process. So therefore, the rationale of increasing the 300 crores to a straight 2,000 crore has been devised. And we are expecting it to see in the next offset policy of 2016, which is going to be released in May, June. Then the offset is required in two categories. In the first category, within the capital acquisition field is the buy global. Now, buy global could be a straight outright purchase from the Indian OEMs or from the foreign OEMs or from the Indian vendors. The second is the buy and make with TOT, transfer technology into India. Now, for the foreign suppliers, the offset is usually 30%. It can be reduced in certain exceptional cases, where it's an exceptional piece of product that we want to import, or it could be increased also. But the general average policy is 30% of the estimated cost of acquisition. The Indian vendors who have set up joint ventures with foreign OEMs, they have to be also obligated to the offset policy in case the indigenous content in the product that is supposed to be supplied is less than 50%. Now, as per the recent policy decision taken by the government, this indigenous content has been reduced from 50% to 30%. So in net, what the impact is, if the Indian IOP or Indian vendor is having a product which is having 30 or 30% more of indigenous content, which is a fairly good number, he will not be required to have any kind of offset obligation. Now, that's a huge competitive edge that the government has given to the Indian vendors. And it is going to have its, we'll discuss the kind of fruits it's going to bear in the later part of my presentation. With respect to the buy and make with TOT category, 30% of the foreign exchange component is what the OEM has to comply with. Now, the discharge mechanism, the avenues for discharge are multiple. It could be through an FDI, foreign direct investment into Indian ventures. It could be through straight exports or purchase of the eligible goods and products. Now, interesting, there was a list of eligible goods and products that is there with the offset policy. Now, in the recent development, what happened was that the services bit was put in abeyance. So you cannot comply with your offset obligations through this provision of services. This was after the Westland-Augusta deal going wrong, so they have suspended that particular part. Now, this was causing a lot of heartburn, a lot of non-compliances in terms of the OEMs who wanted to address some of their offset obligation through services. Now, based on the request from all these lobbying, the government has brought back large bit of the services, which, for example, the maintenance, repair and overhaul, upgradation and life extension, research and development done by the government only have been brought back. Engineering, design and testing and software development services are reinstated only to the effect of 20% of the total overall offset compliances. And there could be a random checks. The one bit of the service which has not been brought back as per the policy is the quality assurance and trading services, because they feel there is an audit, an assessment and implementation issue. How do we monitor this bit of service? The biggest problem in the offset policy so far from the experiences that we have been representing the clients or from the people who have been delivering their offset obligation in India is the huge time lag that you have between when you submit your offset obligation proposal, which is at the time of the bid, and to the time of the evaluation and the finalization and actual implementation. So to counter, and there has been a huge sort of a pushback from the OEMs in terms of rationalization of this particular policy. And as per the recent amendments, which is as recent as August and December 2015, the government has come up with two-pronged policy and a strategy for dealing with the actual implementation of the offset execution contracts. The reason is that as of 2015, only 51% of the offset contracts have actually been implemented which is, and the implementation process has been on from 2008 onwards, and not more than 50% offset contracts have been actually implemented and executed, which is in that sense hurting the Indian economy as well. So the government has come with a two-pronged strategy. One is that instead of making the mandatory submission of the offset proposal at the time of the bids, the government has agreed that at the bidding process, you may just undertake that you will be doing the offset, and you can have the option of either submitting the offset proposal at a later stage, which could be either you have already finished your offset obligations, and at that point of time you come up with the government and submit your proposal and submit your papers with documentary proof, or you can have 1 year window given to the government to approve the proposal that you're intending to discharge. Now this is a huge sort of impetus to the offset implementation process, because it gives the flexibility to the OEMs to come up with the right kind of partner that you're going to be partnering with. Because IOPs, basically the Indian offset partners with whom they have to coordinate and collaborate, it's a long drawn process. You have to identify the right kind of IOP. You have to identify the kind of production and the product that they have the capability to supply, and then matching all of that and adhering to the eligibility compliances. Now this sort of gives them the process. This flexibility gives them the ability to go through 2-3 years of process of understanding the kind of IOP that they would be collaborating with. The only pitfall is that, which is, I wouldn't call a pitfall, it's a sort of a check and balance situation which the government has offered, that in case you're not able to comply with you have submitted your papers and you don't come as an eligible IOP or eligible product that you could have supplied as per the offset policy, there would be some penalty. They haven't described the level of the penalty as of now, but it is possible that the penalty could not be more than 5% as is presently available. With the second stage, which is when you're going to be having a 1 year prior proposal submission, you could end up having a rephasing situation if your product IOP or the product is not eligible, and have a 5% in obligation enhancement. But at the same time, it does give a lot of flexibility to the OEMs to implement the policy. The second issue that we have seen, and I've personally worked with a few of the OEMs with the Defense Ministry in getting the approval to the amendments to the contracts. Now, remember, we have submitted the bids at the time of the offset bids at the time of the submitting of the bidding for the main product. At that point of time, we have decided on a particular IOP. We've decided on a particular product, but it doesn't go well after 3, 4, 5 years when the contract is actually implemented. Now, at that point of time, contract negotiation and contract amendment of the executed offset contract is a huge issue. I've personally worked on some of these amendments, and it has taken more than 12 to 13 months to get the amendment of the IOP, which basically means you have a cascading effect of the IOP not being eligible and all the rephasing required of the offset obligations. So government has now decentralized that from the Raksha Mantri to the Secretary of Defense Production to take the in-house bureaucratic decisions with respect to contract amendments. Now, this is going to give some bureaucratic and administrative ease of getting the contracts amended. Now, these are the changes that the government has already brought in the offset policies. Now, there are certain best practices, international policies, international best practices that the Jhingan Committee also looked at, which is expected to be included in the 2016 offset policy. Some of them, the government has already indicated that they would be looking at, but it's already, some of these suggestions that you saw, the two-pronged approach was part of the Jhingan Committee suggestions, which has already been accepted. Some of the pending suggestions, which the committee has recommended, but we don't know whether they have been accepted so far, I'm going to briefly touch upon that. One is the augmentation of the technology acquisition is a huge step forward for government. It is in line with the Make in India policy decision of the government that we need to have localization of production in India by transfer of technology. So one of the committee's suggestion is that we need to have removal of the 30% minimum cap that is there for the offset compliances for the government institution who have imported the equipment or technology, who have acquired technology from the foreign OEMs. Now, this is to enable that the 30% is a number, but the long-term effect of the technology acquisition is huge, and that's why the 30% should be done away with. The other suggestion is the time frame in offset implementation. Now, normally, typically, what is allowed right now as per the offset policy is during the term of the contract plus 2 additional years. Now, what happens is that since we are going to be having an offset contract implementation over the next contract phase and 2 years, sometimes the long-term goals such as maintenance, overhaul, technology establishment, and transfer of technology and establishment of production units in India, this definitely takes time. And the committee has analyzed the past cases where this could not be implemented within the time frame. One of the companies that I'm working with has the same issue. The MTOT is yet to be formalized and yet to be, the maintenance, repair, overhauls system has yet to be established, and 3 years of the contract is already gone, and we are running in the overphase part of the contract. So, one of the key fundamental of the recommendation is allow the OEM to decide which particular partner and which particular stream to go in, so that there is a long-term effect and benefit to the acquisition process. There are certain other recommendation as well. I'll skip the next 2 because these are, we can discuss this offline, but basically what the next 2 ones are saying is that as of now, the vendor, the main vendor is supposed to, the OEM is supposed to comply with the offset obligation and plus tier 1. The committee is recommending that you can allow tier 2, tier 3 suppliers, sub-vendors in a contract to also come forward and adhere to the offset obligations, and give that flexibility to the main vendor to adhere to those obligations and allow the tier 2 and tier 3 as well to pitch in, though the overall responsibility will obviously remain of the main vendor. One of the very interesting suggestion of the committee, which I really liked, was a subscription to the AI funds. Now, AI funds are basically alternate investment funds. Right now, there is a direct investment, a foreign direct investment option for an offset set-off, which basically means that you can, as an OEM, invest into an Indian company through the FDI route and satisfy your offset avenues. The suggestion here is that most of the OEMs do not have their own, their own companies in India or their own channel and channel partners, and it becomes difficult to set up joint ventures in India. What the committee is recommending is that let us have an alternate investment fund be set up, which is regulated by SEBI, which is already a proper established norm, and let this fund be invested by the OEMs to address their offset obligations. And these AIFs, as they are called, and they are highly regulated funds, they can invest into the Indian IOPs who are eligible for offset policy utilizations. So this is an indirect way of satisfaction where you invest, instead of directly into the Indian company, you invest into the fund, and that particular fund invests directly into the IOPs or Indian joint ventures who are doing defense production and defense servicing bit. I think this is an innovative way to provide growth capital to these IOPs who are always looking for funds but not having any. So, okay. So some of the other suggestions, and I'll quickly go through, is creating a green channel for the IOP. How do we identify an IOP, Indian offset partner? This is the biggest problem with most OEMs. I do not know who to sort of collaborate with. The committee is suggesting that why don't you put a list of these established and recognized IOP on the website so that they know who to go to. And the approval process is minimal because you do not have to qualify them as an eligible IOPs. Similar suggestion is made for approved list of banked offsets. Similar suggestion is for the list of approved offset projects and products. Now, interestingly, out of the $900 million of offset claims which are presently pending with the government of India, only 200 million have been approved. So the remaining 600 or 700 million offset claims are still pending or are being audited and assessed. And for example, in our case, it was rejected, and we were shocked and surprised for the grounds of rejections. Now, this helps once we have a list of approved products and services which have been approved in the past. Gives you a sense of what will muster through the government scale. You know, it gives you a sense of these are the products and the services which will pass through, and that should be put up by the DOT, by the Ministry of Defense. Streamlining in delays in communication of acceptance of offset claims and consequent penalty. Now, this is a big pain point for the OEMs, that after 1 year of following that whether our offset claim is acceptable or not, we get an acceptance letter or a rejection. If it's a rejection, it is coupled with a penalty of 5% for the unfulfilled part of the offset, which basically means it not only imposes a penalty on me, it also imposes a rephasing of my offset obligation for the past year and for the current year and for the subsequent year. So this kind of communication lack between the ministry and the OEMs, it needs to be sort of streamlined, needs to be moved forward. One more suggestion which is interesting is the shifting of pre-approved work amongst pre-approved IOPs. What basically means is reshuffling of the offset avenue work which is already approved between the approved IOPs. So instead of, suppose Wipro has been approved for software development, it can, and the HCL is also there for some other IOP work, there can be a reshuffling between these two group of IOPs as long as they are both pre-approved. Banking of offset to be permitted for all avenues of discharge, including technology acquisition. Basically, technology acquisition currently is not allowed for banking of offset, which the committee is suggesting that since the technology is a way forward for Make in India, for defense industry, this is definitely a yes for the offset banking. Some of these suggestions we may see in the 2016 policy or an iterated version of it, but we hope most of them are accepted. Now, what is the way forward for the private players? Now, interesting bit about the offset policy is that around $5 billion of offset contracts have been implemented in the last 6, 7, 8 years. And there are 15 more billion which are pending implementation. That's a huge amount of funnel for the private players. And then another interesting facet is that 60% of what has been already executed has been taken over by the private players, whether it is Tata or L&T or Wipro or HCL. 60% of the existing 5 million funnel, which is an executed offset contracts, have been undertaken and implemented by the private player. So there is a huge opportunity for the private players. What was in the past has been further relaxed and liberalized. One interesting bit for the private players, if they're looking for offset, is that the FDI has been liberalized for foreign direct investment from 26% to 49% on an automatic basis, which basically means you could be an Indian IOP, an Indian offset company, doing defense production into components and other parts and services, and you can receive 49% of the foreign investment directly without any approvals required in most of the circumstances. This is a step forward. For last 15 years, we were stuck with 26% with approvals. Now we have a clear automatic window where you can simply receive the funds and get going with your production. That's another step forward for the private companies to augment their defense production capacities. Now, this is going to be coupled with the new scheme, which is yet not announced, but is going to be you would see it in DPP 2016, which is the Indigenous Design, Development and Manufactured Scheme. Now, this basically means where the Indian company is submitting the bid, and he has the facility of internal and Indian design, he will be the priority person to get the defense procurement contracts. So in the list of priorities, this scheme of indigenous designing, and I heard previous speakers talking about how the PSUs are into the indigenization of the designs and technology. That's where these are the private players or PSUs who are going to be the first in the priority list of development and being procurement partners. Coupled with that, the reduction in the indigenous content threshold for the Indian vendors, which helps them to avoid the offset policy, gives them the competitive edge. I think the Indian players, whether it is a PSU or a private partners, have a lot to contribute, considering we have now some liberalized schemes and policies, and the impetus being given by the government to the Indian players with technology development schemes to come up, coupled with the FDI scheme. The way forward, obviously, is that one of the suggestions from our side is that the past developments and the new developments that have till date happened are not available to the current under implementation offset contracts, which basically means if I have got a contract, offset contract under the DPP 2013 or 2008, I will not be eligible for all the new developments that are happening. This needs to be made retrospectively effective so that I as an IOP is able to, as an Indian player, is able to take the benefits of these policy decisions. But obviously, the proof of the pudding is in eating, and the government has come up with the policy. Now it is up to the Indian players to sort of augment their capacities and move ahead with the policy initiatives that the government has taken. Thank you. I'll be available for questions.
Thank you, Mr. Jhingan, for sharing the updates on the offset policy. We have about 4-5 minutes for Q&A. Just one question from my side, and then I'll take the questions from the floor. Mr. Jhingan, you were talking about the AIFs, the funds. Is there any global experience or global cases for such funds internationally?
I think this was Mr. Jhingan's own initiative.
Own initiative,
AIF
okay.
is a local Indian concept.
Maybe you could use the next other.
So AIF is an Indian concept where a scheme of venture capital funds and PE funds have been established by Indian regulatory system. So it's a very Indian concept for which they have tried to use.
Sure, thank you. I'll take some questions from floor. Rules are simple. Identify yourself and keep the question short, starting from the right. Any questions or comments from the right side? Moving on to the left. Any questions or comments? Well, I have another question then. Mr. Jhingan, is there also a provision for change of IOP? Any recent amendments on that within the policy? If you could throw some light on that.
Yes, so the current policy allows the change of the IOP, but it's a very process-driven scheme where you have to apply and the Raksha Mantri himself has to approve for it. The new policy has allowed there is a standard operating procedure which has been brought in where the Defense Offset Management Wing has been empowered to deal with any kind of amendments in IOPs as well as product component, and the Secretary of Defense Procurement will be having the power to take the decision.
Sure. Dr. Behra, I should ask you right now here that you've also studied in depth on the offsets, and I have any comments from your side on offset? The mic is towards your right, sir. Towards your right, Dr. Behra.
Well, I think as far as Indian offset, I don't want to comment in this public forum, but this is my personal opinion anyway. So I think offset is one thing we have been very easily influenced by other countries, particularly from South Korea, which the Calgary Committee studied and recommended for the Ministry of Defense, and they readily accepted. But they have learned nothing from the experiences of other countries. We brought out a big study, I think 2-3 years ago, showing that Indian offset policy is very conservative. It gives all the freedom to the foreign companies, and the foreign companies misuse the offset policy left and right and dumped whatever thing they could to India. And we have got nothing absolutely from the policy so far. So a good thing that the ministry is thinking of directed offsets, that whatever offsets they want to get, they can specify in the RFP itself. So hopefully they will survey the Indian industries or the armed forces requirement. They can stipulate whatever the technology or high-end manufacturing in the RFP itself. So that will be a precondition for the foreign companies to participate in the bid.
Sure.
But otherwise, offset will work only when you have a strong implementation and monitoring agency. And that has been a big failure in our case.
Sure. Thank you. Thank you for your comment. Mr. Jhingan, also, you also mentioned about right now about 51% of the contracts for offset have been implemented. Now, in the advent of recent amendments, which happened last year, and the new policy, which is expected, some more amendments this year, where do you see that going in future?
So there are 44 contracts which are in the pipeline right now, which is aggregating to some 15 billion approximate numbers in terms of offset contracts. Now that's a huge number, and their timeline for their implementation is 2028. Considering that we have only settled claims of 900 million so far, and we have 50 million offset contracts to be achieved, it is a huge opportunity for the Indian IOPs to lap onto it and provide services. So I see a huge potential there.
Sure. And in your opinion, which is the one biggest challenge which needs immediate attention to, have a bigger opportunity or be able to honor the offset contracts right now?
I think there are a lot of Indian capable companies available in India, but who don't have the wherewithal to reach out to the OEMs. And the reverse is also true, that the OEMs are also struggling to find the right kind of IOPs. A suggestion has been made that IOPs has to be a platform where the designated and eligible IOPs are introduced, and there has some synergies being created for the IOPs and the OEMs. I think that is a step forward which needs to be looked at. Why most of the IOPs, why most of the offset contracts haven't happened is also because of mismatch of the OEMs and the IOPs. That has been a biggest challenge, and in some of the cases that we handled, there was situations when IOPs and the OEMs contracts are there, but they couldn't implement because of the mismatch, and there was penalties imposed.
Thank you. On that note, I think I'll bring the session to a close. Thank you so very much, Ms. Jhingan, for joining us today. Thank you for your time.